law firm concentrated in men's and fathers' rights in divorce, custody, and family law issues, with offices in Nutley and Montclair, New Jersey. Today is Thursday, August 29, 2019. This is in New Jersey, as I mentioned, so if you're listening to this on any other day or in any other jurisdiction, you have to make sure that the advice I'm giving you still applies where you are. Today is my weekly how-to series. I'm going to discuss briefly how to decide if you need an expert witness. And I'll give just some brief explanations about the types of expert witnesses, but this is a very important topic. I try to give as much information in as short a period of time as I can, but you should always consult with an attorney, especially on topics such as this, where are complex and will vary depending on your case. That being said, how to know when or how to decide what type of expert witness you need and whether or not you need one. First, start out with the fact if you're in that conversation of whether or not you need an expert or not, you probably do. Experts will normally be involved when there's any kind of complex issue that you are not specialized in or experienced with to assist in explaining. The technical definition would be any person who has specialized knowledge that would assist the trier of fact, which means anybody who has special education, experience, or knowledge of some sort can serve as an expert witness. In some cases, that may be you. You may have a specialized knowledge, but most of the time it's not going to be. And even if it were, judges won't accept readily that you are objective and don't have a bias towards your side. So on complex issues, you would likely need an expert witness. Most commonly, they're going to be custody issues and best interest analysis for children, employability for spouses, economic and finances for lifestyle, business evaluations, and anything, again, that would be a complex issue in a divorce and even in a custody matter, but this is limited mostly to divorce. Next would be what type of witness do you want to use, and aside from what I just mentioned as far as the class, like custody and employability, the type means do you want to use a joint expert, a separate expert, or a court-appointed expert, and they all have advantages and disadvantages. If you have a court-appointed expert, that is where the court says this person is going to work as an expert, and the two parties usually are sort of agreeing, or even if you don't agree, somebody had requested it, so the court's appointing it. The good thing about a joint court-appointed expert is, first of all, the court chose that person, so hopefully they're picking somebody who's experienced and not biased. The costs will likely be split, and nobody's picking their own expert, so there's no advantage or disadvantage. And lastly, and most importantly, you will still reserve the right to get your own expert if you aren't happy with the decision you get from the court-appointed expert. That's probably the greatest advantage, because you have a chance to get a report from an independent expert that's court-appointed, that you're saving money on because you're splitting the costs, and you're not necessarily bound by the decision. So if you like the recommendation, great. And if you don't, you still have the ability to get your own. Next would be a joint expert. Now, a joint expert is similar to a court-appointed expert because you're both choosing it, but instead of having the judge decide, the two parties are deciding and moving forward. Now, the advantage to that, similarly, is you're both agreeing to somebody, so there's usually no bias, there's no conflict or relationship. You're also usually splitting the costs somehow, and it makes it faster and less expensive. And in most circumstances, you still are also reserving your right to your own expert if you're not happy with the joint. But that's not always the case, so you may want to specify that in any court order or consent agreement. If you are consenting to a joint expert, you want to put that you're reserving your rights to an independent, separate expert afterwards. And last is a separate expert. You can do that in the beginning when somebody's asking for a court-appointed. You can do it before an expert comes up. It's your own expert, you choose it, and you pay for it. The good thing about that is it expedites a lot of litigation because, as I said before, with a court-appointed expert and a joint expert, everybody reserves their right to get their own expert. So if you wait all this time for your court-appointed report, then you get your own, and then the other party gets their own. You have a lot more time and a lot more expense that goes into getting all these reports done. A separate one, you're getting one, and that's the only one you're getting. The other side is getting one, and that's all they're getting. The bad thing is if you get a report that's not good, you're locked into it. You can't now say you're not happy with your expert. Even if you got your own expert report and you didn't tell the other side that you had hired the expert, in any kind of complex litigation, usually somebody's going to request in pre-trial discovery, which is the information you exchange before you go to a trial, to provide the names and reports of any experts that you utilize that you're not going to rely on at trial. So if you thought you could just shove the report in your back pocket and not use it, it's not likely to happen. Not only will they get another copy of it, they'll also find out you didn't plan to use it, which means they know it's not good for you. Is a rebuttal expert, which may fall into lines as the separate. You're never going to have a court-appointed rebuttal or a joint rebuttal. Rebuttal is to rebut the either court-appointed or the independent from the other side. The advantage to a rebuttal witness, because this is a separate witness, so it comes with the disadvantages of you're bound by the report and it's a little more costly. But you're getting it after reading the first report, or first expert report, which would either be a court-appointed, the joint, actually not joint, be court-appointed or the independent. You now can get an expert for the limited purpose of rebutting what the negative report was for. Probably the best type of witness to get. Unfortunately, they're the least common because in a litigation track, you're usually told when you have to get reports and when they have to be done. They usually won't let you do all the discovery and get all these reports and then let you get a rebuttal. So you may need to reserve that right in the beginning. It may also partly depend on what type of expert that you're receiving. So like I said, if you're taking a separate one in the very beginning, you're not likely to get a rebuttal unless it's set forth specifically in the court order setting forth the original schedule for all expert reports. Now, the last thing to know about expert reports, and it's the most important and it's probably the worst thing about them, is a judge is technically not bound by any expert report, even if he or she appointed the expert to do the report. I'll give you, for instance, I had a custody case years ago, where mom had alienated the children from dad so badly that whenever there was a question of changing custody, the children would say that they were going to kill themselves. Very traumatic, and some of the courts react very quickly and promptly to. So in this case, the court appointed it was a joint court-appointed expert that had been involved in the family and in the litigation for 8 or 9 years, knew the case, knew the parties, knew all the history. That expert wrote a report that said the children have been trained to say this. It's not true, they don't mean it, and there's no risk to the children. They would be best by being removed from their mother because she's doing this in place with their father. The court said, thank you for the report, I'm glad you did it, after he appointed and said, we're not following it. And simply because the judge was too concerned for the safety of the children, he was not going to change custody no matter what the expert said. Makes you wonder why he even appointed it, but they need to have expert opinion to assist them. That's why the standard is specialized knowledge to assist the trier of fact, which is the judge, but they're not bound by it. So you can spend all this time getting court appointed, getting joints, getting rebuttals, getting separate, and the court doesn't listen to any of them. So you need to pick carefully and you need to plan your case carefully to make sure that your expert report truly is going to help the judge decide the facts and not just somebody's going to give you a report that pushes your side. I hope this information helps. If it did, please give it a like and share it so that others get to see it. I will be off for the holiday weekend, so I'll be returning on Tuesday. If there's anything that you want me to cover specifically, just send me a message and I will do my best to address it. With that, I'm going to sign off and wish everybody a happy holiday weekend.